to have you here. Welcome also to all of those who follow us on Zoom, or those who follow us directly by video on our website, www.pressclub.ch, and you can watch this also on YouTube or Facebook Live. So we are going to discuss today here the decision taken on 31st of August by the Human Rights Committee about Catalan independence and about the suit, the procedure that was introduced against the government of Spain concerning the question of independence and those who supported the independence of Catalonia. To discuss this, we have with us today Nico Krisch. He is the representative of the applicants of this procedure against the government of Spain that was introduced at the Human Rights Committee. And he is also an international law professor at the Graduate Institute here in Geneva. Welcome, Mr. Krisch, and I give you the floor.
Thank you very much. The microphone is good? Yeah? So welcome, everybody. Thanks for coming. I'm very happy that you're here, and I'm very happy about those that have connected online, because it's a good day. A good day, obviously, for the applicants who have won an important case in the UN Human Rights Committee. It is also a good day much more broadly for the cause of justice, because where justice has so far been denied in Spanish courts and Spanish institutions, the United Nations have managed to bring it into the process, and we very much hope that this will have important consequences further on. Now, the decision of the Human Rights Committee that we're going to talk about today is about a concrete, particular aspect of the broader conflict between Catalonia and Spain. It is about this concrete issue, but it has much broader furtherances for the way in which Spain conducts its strategy of repression against the independence movement, and I'm going to talk a little bit about what this implies much more broadly. So, the particular issue that these proceedings were about is important because it encapsulates many of the much broader issues that arise about Spain targeting political actors, peaceful political actors with the tools of the criminal law for the pursuit of their political ideas and political strategies. Now let me say something about what it was concretely about before we get to the broader issues. Now the four applicants, of whom only one, unfortunately, can be here with us today, Oriol Junqueras. The other three are in Barcelona and are connected with us online, but unfortunately couldn't be here today. The four applicants were in the leadership of the two main independence parties, pro-independence parties in Catalonia prior to the referendum of the 1st of October 2017. They were part of the regional government, the Generalitat, as the vice president, Oriol Junqueras, or as conseillers or ministers in the regional government. Now they supported the referendum and campaigned decidedly but very peacefully for independence during this time. Now after the referendum had been held, as everybody knows, there was a phase of very serious tension characterized by heavy violence on the part of the state, trying to repress the referendum in the first place, and the later protests that erupted in the streets of Barcelona. From late October 2017, the four applicants, Oriol Junqueras, Raül Romeva, Josep Rull, and Jordi Turull, among others, were criminally prosecuted, especially for the crime of rebellion, which implicates a violent uprising under Spanish criminal law, a provision that had been created initially primarily for dealing with coups d'etats and armed uprisings that involve military force and something of the sort. Now, they were prosecuted for this despite the peaceful nature of the protests. They were taken into pre-trial detention from early November 2017 up until the end of the criminal trial that finished in October 2019 with a short interruption of a few months for Raül, Romeva, Josep and Jordi Turull, whereas Oriol Junqueras remained in pre-trial detention throughout the entire time. Now, meanwhile, the government and the parliament had been dissolved. The Catalan government and parliament had been dissolved by the Spanish government on the basis of an emergency clause, with the result that there were new elections to be held in December 2017. Now, in these elections, all 4 applicants campaigned, were re-elected as members of the Catalan Parliament, and their parties gained the majority of seats, so they could form a new government. Now, there are many complications as a result and as part of the repression, but they were not the precise focus of the proceedings we have before us today. The important element here is that even though they had been elected as members of the Catalan Parliament, in July 2018, the investigating judge of the Spanish Supreme Court decided that they should be suspended from their parliamentary mandates. That is, in the first place, to most of us, surprising. How can that be? It is the result of a clause in the Code of Criminal Procedure in Spain that says that if somebody is formally prosecuted, proceedings are formally opened against them for the crime of rebellion, and they are held in pre-trial detention, they are automatically suspended from their public office. And that includes elected office like any other public office. And the investigating judge implemented this clause and asked the Catalan Parliament to suspend them. Now, obviously, that is, for most people, problematic because a trial had not taken place, guilt had not been established, and as a result, it was kind of on the basis of a mere suspicion that these suspensions were decreed. Now, they were challenged in the Supreme Court, and they were challenged in the Constitutional Court without success. And as a result of that, the applicants decided to bring a case in the United Nations in order to vindicate their right to sit as members of the Catalan Parliament in execution of the election result of 2017. So in December 2018, we took that case to the Human Rights Committee, and we should thank some of the obviously people who have supported us, especially Òmnium Cultural and the Assemblea Nacional de Catalunya, who have supported the possibility of bringing this claim. It was also remarkable because it brought together applicants from the 2 different parties in a joint venture to fight this case. Obviously, as the Human Rights Committee operates, it takes some time until a decision arrives, but the decision has now finally arrived on Wednesday, and it finds that there's a manifest violation of Article 25 of the International Covenant on Civil and Political Rights, which guarantees that every citizen shall have the right and the opportunity without unreasonable restrictions, among other things, to vote and to be elected at genuine periodic elections, guaranteeing the free expression of the will of the electors. So that is, as the committee says, the essence of democratic government that is protected there. It is a very important provision in the international covenant. The covenant has been ratified by more than 170 states worldwide, among them Spain, since the late 1970s. Now, there can be some limitations imposed on this right, but these limitations have to remain within a framework that is reasonable and objective, as the committee says. And the committee finds here that the provision, the right to participate in elections and to be elected, has been violated because that reasonability and objectiveness has not been fulfilled, largely for two reasons. One is that there has not been any individual assessment of the proportionality or justification of the measure so stringent as to remove an elected parliamentarian from office, largely because it was taken to be an automatic consequence of the legal provision in play. And an individualized assessment of the proportionality of the measure would have been especially important because it was enacted prior to a criminal conviction on the basis of mere suspicion brought out by the accusation, and because it was based on peaceful acts, not violent acts, where clearly the threshold would be much higher. So the result of it all, and I can speak more if there are questions about the details of the decision, is that Spain has to acknowledge that there has been a violation of the covenant as a result of these actions. It would have the reparation to repair the damage. Now, to an extent that is impossible because new elections have been held later on, so the 4 applicants cannot be restored to the Catalan Parliament as a result of this decision. Now the election period for which they were in Parliament at the time kind of has passed. But the committee very much insists that the government of Spain, Spain as a state, all public organs, have to ensure and take measures to ensure that no such thing can happen again in the future. Now, what's the relevance of this decision then going forward? Now, in the first place, it is a rare case of a clear victory. The committee typically tends to couch its decisions, views as they are formally called, in somewhat diplomatic language, giving both sides something. Now, in this case, it is a very clear finding of the large majority of the committee that there has been a violation of Article 25 of the Covenant. Now, Spain needs to implement, as I said, it has to take measures to avoid repetition of this. This implies the courts that, of course, cannot do something like this again. But as I said, because it implicates legislative measures, this provision in the Code of Criminal Procedure in Spain, it is clear that a proper implementation of the views of the committee would require that Spain take legislative measures to abolish that clear linkage, probably reform the legislation, the criminal code legislation on which it is based, which opens the door to abusive interpretations of the crime of rebellion and sedition, which are relatively unheard of in other Western democracies, and take forward a reform that would make sure that if such provisions are maintained within the Spanish criminal code, they cannot be used against political opposition without clear indications of violence. Now, I'm often asked whether Spain actually has to do something as a matter of law as a result, or whether this is not just something political at the United Nations. Now, it is very clear Spain has a legal obligation under Article 25 of the Covenant, as a result of its ratification of the Covenant, to implement the rights of the Covenant. And the committee, as the authoritative interpreter of the Covenant, has told us that there has been a violation and what the violation is, so that Spain has a very clear guidance on how to move forward. Spain also has ratified the optional protocol that gives the committee the power to review individual communications, as they're called, as the case that we had in front of us, and it therefore has a good faith obligation to cooperate with the committee and to consider how to implement the views of the committee best. In the case of Spain, there's an added element that has to do with Spanish law, because Spanish law, more than other countries' laws, provides that there's a clear linkage between Spanish law and constitutional law and international treaties for human rights in Article 10 and Article 96 of the Spanish Constitution. It provides for a direct relevance of the covenant in Spanish law, and Article 10 provides for the need to interpret the Spanish Constitution in line with international treaties on human rights, of which the covenant forms part. So in the future implementation and interpretation of the Spanish Constitution even, the the requirements of the covenant have to be taken into account. Now, there's obviously no direct enforcement of this decision on the part of the United Nations, in the sense that we would think of a police going in and forcing actors. But obviously we know that much law, including constitutional law, doesn't work on the basis of enforcement through police, but instead operates on the basis of actors complying with the requirements of constitutional law and international law because they believe it is an important element of the democratic legitimacy of a state and of a government. Now here too, the question is whether the Spanish government and judiciary want to be seen as within the international rule of law or without. Western democratic governments do not normally simply flout or ignore committee decisions. Such cases in the first place about political rights, as we've seen here, arise normally for countries with serious democratic problems or even autocracies. Think of cases such as Turkey, Venezuela, the Maldives, or kind of recently Brazil in the case of Lula. The kinds of countries that are concerned here is not necessarily the company Spain would want to keep. If Spain wants to return to the fray of full democracies, it needs to pay attention to what the committee has said. And this is especially so because the committee is not alone. It is probably the most important finding so far from an international body that the criminalization of the response to the political movement for independence in Catalonia is unlawful and inadmissible. But of course it follows in the tracks of a significant number of other findings that Spain has seriously violated the rights of activists and politicians, and all those that have campaigned for independence. That concerns the UN Working Group on Arbitrary Detention, which already in 2019 found that the detention, the pre-trial detention of 6 of the people concerned, the applicants in those cases, was unlawful and not in keeping with international human rights. 3 of them are among our applicants. The Court of Justice of the European Union, who has found, for example, in the case of Oriol Junqueras, that Spain had violated rights to political participation in making it possible to take a seat in the European Parliament. A range of courts in other European countries, especially Germany, Belgium, and in Scotland, that found that the exilees, among them former President Carles Puigdemont, could not be returned to Spain because of serious problems of legitimacy of the surrender, the arrest warrant that was issued for them. The Council of Europe Parliamentary Assembly that last year came out with a very strong report urging Spain to stop the criminalization of the pro-independence movement and to reform its criminal provisions so that they cannot be used by the judiciary and prosecutors to be used against the movement. So we have a whole picture that reflects a growing consensus of international bodies, human rights bodies, and courts that the strategy of oppression that the Spanish government has used is very much beyond the frame that liberal democracies have in order to deal with legitimate, peaceful opposition, even if that opposition aims at changing the constitutional structure of a state. There's a clear jurisprudence, for example, from the European Court of Human Rights, that says that any kind of such fundamental opposition, even if it aims at a general restructuring of the state, something like the independence of a part of the state, has to be admitted as part of the political process unless it is executed through violent means. Now that is clearly what Spain has not done. So all this comes together. Nevertheless, apart from the cases that we've been now talking about directly, there's still more than 700 criminal prosecutions and cases in criminal courts open in Spain against members of the pro-independence movement. And Spain clearly, if it wants to heed the calls from international bodies, including the Human Rights Committee, has to end that strategy of oppression. Judges need to cease. the government needs to take effective measures to make sure that judges cannot use the existing laws in order to criminalize what is a peaceful opposition. Otherwise, there are likely to be many more such findings from international bodies. There are a number of cases, both in the Human Rights Committee, in the European Court of Human Rights, also against the criminal sentence that came in 2019 with very draconian criminal measures, punishment of 9 to 13 years in prison for the acts that we're talking about, equally long disqualification from office, clearly beyond the realm of what could be admitted in a liberal democracy, and the pardons enacted last year have only partly remedied that. Obviously, they have not admitted the unlawfulness of those measures from the start. So, unless Spain clearly changes tack, much more will be coming from international bodies. As we see, the European Court of Human Rights is clearly taking note of what is happening in those UN bodies, and it is very likely that further proceedings will result in very similar findings from international bodies. So, thank you very much.
Thank you very much, Professor Krisch. So now we open the session to questions. Other questions, please tell you your name and organization, sir.
From Raül, Barcelona. I have some questions. The first one, do you think that this statement from the UN will be an important argument for the European courts in the future resolutions about the pro-independence movement? This resolution about from the UN says that Spain has 180 days to report on its changes it has made to implement the resolution. What happens if there is no change in Spain? And last one, are the pardons sufficient reparation as the government of Spain said? Thank you.
Yeah, thanks. 3 points. Kind of clearly, these are very important arguments for any kind of future proceedings in both the European Court of Human Rights and in national courts having to find on potential extradition requests of the exiled politicians, as well as in the European Parliament, where issues are debated about the European Court of Justice, issues are considered about the immunity of current members of the European Parliament. So clearly, the string of condemnations that I've talked about, of which the Human Rights Committee is, I think, the most important one, very much bolster a case also in those courts that the general strategy of repression is unlawful. And it is very likely that it has significant weight in all those other proceedings, even if they concern technically somewhat different elements, but many of the arguments that have been brought forward in the committee are largely the same, and the emphasis on the impossibility of using such draconian measures against a peaceful movement is equally applicable to those other cases. What happens if Spain does not change something? So indeed, kind of it's the standard procedure for the committee to ask for reporting on what has happened in response within 180 days. Spain will have to report on that. The committee has a follow-up procedure in which it then considers whether countries have taken measures to implement, and it comes out with a report on that. It might ask the government again to report again in the future. Obviously, the committee cannot force Spain to do something, but every further step of non-compliance, as we've seen also with the decision of the UN Working Group on Arbitrary Detention at the time, every step further into non-compliance with international demands puts Spain further out of the realm of the family of democratic liberal states, and obviously causes serious reputational problems in the United Nations and within the Council of Europe and the European Union. Has the pardon been sufficient reparation? Clearly not. The pardon is not a full reparation even of the prison sentences that have been enacted. It hasn't done anything about the disqualification from public office that still weighs on the applicants as a result of the criminal sentence. It also hasn't done anything about the particular the particular question in front of us, the suspension from office that was enacted. In order to do proper reparation, Spain would have to admit that this was a violation of their rights, and it would have to acknowledge that also in court proceedings that could be brought, for example, for questions of compensation. So there's way more to be done in terms of reparation, and especially looking forward in order to avoid repetition of the same issues, as I said, through legislative or judicial measures.
Thank you. Is there any other question in the room? Or also you can ask your question for those who follow us online, raising the electronic hand. But there is a question here. Just wait the mic, please.
So my question is simple. Do you have any other organization? David Melgarejo, TV3, Barcelona. Do you have any other organization where you can go with to have another decision of the community, international community, or the United Nations is the last where you can go?
So obviously at the universal level, the UN is the pinnacle, in a sense, of the system. Kind of that's where, in a sense, all countries of the world come together in order to agree on and implement common values, as has been done through the Covenant, the Human Rights Committee, and other UN bodies. We've already heard about the working group. There are other treaty bodies in the UN that might potentially play a role, special rapporteurs, but the Human Rights Committee is somewhat the closest that we come to a sort of World Court of Human Rights, even if it is not formally a court, as a quasi-judicial instance. Where else could one go? Obviously, within Europe, the Council of Europe is the second main pillar of the human rights architecture, with the European Court of Human Rights, but also the bodies under the Parliamentary Assembly that pursue questions of human rights compliance, which in part has taken place and would need to be pursued further. These are really kind of the two main sites in which to pursue this. There are other bodies like the International Parliamentary Union, for example, that has been involved, but it is a somewhat more discrete procedure in which the International Parliamentary Union can come in to protect the rights of parliamentarians worldwide, kind of another aspect. So there's a kind of a broader landscape, but what we've seen here has really been action at the center of it.
Thank you very much. Is there any other question? Other questions online? Not yet. Perhaps let me ask one question to you. Carlo Puigdemont was not part of this procedure, if I understand. Can you tell us why? And will this decision by the Human Rights Committee have an impact on his fate as he's still in exile?
Yeah, obviously he was affected by the measures of criminal repression in a different way because he was in exile already at the time. So there was in a sense, kind of this different. There's a different case pending for him at the Human Rights Committee, on which the decision is expected sometime soon. That also involves other aspects of the impact on his political rights. So in a sense, it's formally different proceedings. It is pretty clear that what has happened now in the Human Rights Committee with the particular case of the 4 applicants is very likely to have a significant weight, as I said, also for the European Court of Human Rights, but much more so for the Human Rights Committee. Any future decision of the committee will obviously stay in keeping with the general tenor of what they have decided this time, largely coming out very critically against the possibility of using the criminal law and criminal procedure against a peaceful movement of opposition. And those same questions will play a role, or the central role really, in the proceedings on his case. So I'm very confident that this will have a significant weight there.
How long will it take to clean all these legal procedures? There are many that are in place right now. You talked about 700 cases in Spain. How long can this take? And is there any chance that the political situation in Spain can be reversed, that the independence could be either that there will be another vote about that? How do you see politically the future of this question? I know you are a lawyer, but still.
Yeah, so that's beyond my particular element of expertise, and so I can't look into the crystal ball of how things are gonna develop. I mean, it's clear that kind of from the string of cases that we've had here that the Spanish government and parliament would need to do something serious to deal with the repression of the first round of kind of the independence referendum. Also, actually, a criminalization of the prior consultation in 2014, which already had criminalized the peaceful expression of the self-determination of the Catalan people. Again, for the 2017 referendum. So there would have to be really stringent measures, not just pardons in individual cases, probably an amnesty and a serious reform of the criminal code to avoid this happening again. One should also note that the Spanish parliament actually in the 2000s had decriminalized the holding of a referendum. It had taken this out of the criminal code. And so prosecutors and judges have brought it in through the back door by using these very open criminal provisions of sedition and rebellion that, as I said, are not to be found in many other Western European countries or countries of kind of liberal democracies. So what is going to happen in the future kind of very much depend on how on the question of how the relations between Catalonia and Spain can be taken forward. There are very different views, I know, within Catalonia about this. Much will depend, I think, on the question of, sort of to what extent Spain continues the repression that it has engaged on in the first place, whether it yet strengthens it further. It might happen as a result of an electoral change within Spain, but it's really difficult to tell. I would foresee that sooner or later we will see a replay of what has happened before on the basis of the legitimacy that the initial referendum has given the movement in its claim for independence and self-determination, to vindicate this, because there has been a whole generation of independence movement that has been created as a result.
Thank you very much for these views. Are there other further questions in the room? Are there more questions online? Tobias? No questions. So if you don't have anything to add to your, or to state for the ending this press conference, no? Then
doncs potser que pels catalans, bueno, sí que era un honor per mi de representar els demandants en aquest cas, i soc molt feliç que ha sigut un èxit tan contundent com ha sigut, i espero que podem continuar la lluita jurídicament i políticament al futur. I moltes gràcies a tots que ens han ajudat, als advocats, però especialment als demandants, als grups polítics i als grups de la societat civil que han sigut un molt important suport per tot això. Moltes gràcies.
Thank you very much, Nico Krisch, who is the legal representative of the applicants of this procedure that was won at the Human Rights Committee 2-3 days ago. Thank you very much. Have a good afternoon and see you back at the Geneva Press Club.